Hello everyone, welcome to today's IPTA webinar. My name is Andrew Jones. I'm on the Education Committee along with John Landells and Janelle Borum. Welcome. So a quick housekeeping matter before I introduce today's speaker. I'm chair of the IPTA Future Directions Committee, and we recently sent out to all members a survey about a fortnight ago. And what we want to know is what you think IPTA does well and what you think IPTA could do better. So thanks very much to the 167 members who thus far have filled in the survey. That's greatly appreciated. But what's become apparent is that quite a few surveys haven't been received. So can I ask that if you haven't received the survey and it was issued on Tuesday a fortnight ago, I think that was the 4th of September, just check your junk email, and if it's not there, can you please let Chris at IPTA know, because it might be that your firm's firewall has blocked it. Some of the firm's firewalls, we're aware, haven't let it through at all, and we can't find it, and we're going to need to resend it out to members of those firms, and it would be better to if we knew that your firm was in that boat as well. Other housekeeping matters, if you have any questions, as always, please type them into the question box in the GoToWebinar window, and I will present them to today's speaker at the end of the talk. So I'm quite excited about today's talk. As patent attorneys, we have a very specific skill set, and often not one that allows us to advise clients about commercial or legal aspects of their business without stepping outside of our appropriate competency. So it's always good to know, therefore, when to recommend to clients that they should seek further advice, and that they should seek further advice from a lawyer such as our speaker today, Peter Karcher. So Peter is a partner at the law firm ClarkeKann Lawyers, who have offices in Sydney and Brisbane, and according to his website, leads the intellectual property and media and technology practice groups, and is a member of our business transaction group. Peter advises on the acquisition and disposal of businesses, commercial contracts, IP protection, private investment and fundraising, shareholder and partnership agreements, corporate restructures, joint ventures, government tenders and IP disputes. And as you'll appreciate, there's a lot of overlap there with what we do, or certainly what we lead into. I was interested to see that Peter has provided IP advice to Giant Bicycles, and I've made a note to myself to ask if I can be involved if this ever happens again. Quite like Giant Bicycles, although after having fallen off my giant mountain bike multiple times whilst riding around Bantry Bay on the weekend, perhaps the love affair is over. Anyway, enough of that. I'll now ask Peter to begin his talk on IP licenses and shareholder agreements, a commercial legal perspective.
Thanks, Andrew. And thank you to IPTA for giving me the opportunity to speak to everybody about these topics, IP licenses and shareholder agreements today. I think, look, Andrew hit it on the head really in his introduction in terms of what my objective out of today is, and that's really to try and give all of you guys a bit of a value add, if I can, in terms of, you are the trusted advisors to your clients, you've got your technical field, but they're going to come to you for areas that are outside of that, and the purpose of this is not to make you guys experts on IP licenses or shareholders agreements, but to just give you a flavour of what's important, what they involve, and so that you can, when your clients come to you, that you can point them in the right direction, or at least identify issues or put the red flag up if there's something that you can see that they need to deal with. So we've got a fair bit to get through, so I'm just going to launch straight into the IP licenses part of things. So what I want to do today, what I want to run through is sort of a checklist that I've got of the elements of a license agreement that I actually find helpful to go through myself when I'm advising a client or I'm drafting an agreement. But just before we do that, just to sort of set the scene, it's worth saying, well, what are we actually talking about here? Because IP licenses come in a bunch of different forms. Anything from your what I'd call sort of a foundation sort of cornerstone agreement for a licensor, for say a creator of intellectual property or an IP owner, to find a partner to commercialise and exploit that IP. But there are lots of other ones. You might be a more mature IP owner who has the ability to, say, do distribution yourself. You might have your own technologies, or you might develop new IP. You might just need somebody to manufacture it for you, so you might need a manufacturer and supply agreement, which is going to obviously involve the license of that IP. I do a lot of work in sort of the software and digital technology area, and you have what is a little bit of a misnomer, but reseller agreements, where you have sort of software vendors who are looking for distributors in different territories, and sometimes that can be what we call a pure agency arrangement, where the actual distributor is not actually party to the agreement, but more often than not, that's going to involve a license, sub-license arrangement of the IP, a license to the what they call the reseller, and then a non-license to the end client. And then you've got your end user license agreements, which, as it says, still in the software area here, but your license for your end user, which is these days more and more the software as a service type platform offering. But back in the days, we still have the old on-device, installed software kind of arrangements, all IP licenses, and then there are sort of a million different variations of that for trials in early stages of IP, for licenses for one-off projects, tender bids, teaming arrangements. They can all involve IP licenses. And then you've got sort of internal or related party licenses, and I do a lot of this for clients where you're actually structuring IP within a corporate group, which might be for asset protection, or it might be to allow flexibility of licensing. Probably today I'm going to be talking most about the first kind of category of licensing, where it's a sort of an important fundamental sort of licensing step for an IP owner, and mainly from the licensor's perspective, but I'm going to mix it around a bit. The point is that, while these are different creatures, they all have a lot of fundamental elements in common, and that's what I'm going to go through now. So when I've sort of got a bit of my checklist, I sort of divide it up in my head into sort of more commercial issues that need to be dealt with or negotiated, and then more legal technical issues. So I'm going to deal with the commercial ones that come up first, maybe. So obviously, exclusivity is going to be one of the biggest issues. Are you licensing your IP exclusively, or is it non-exclusive? If it's exclusive, it's obviously higher stakes generally. So you're going to want to have some checks and balances along the way if things aren't working out for your licensee, and we'll talk a little bit more later on about how that can look. What's the term of the agreement? How long are you going to lock up the IP for? If it's an exclusive license, you have to be thinking about things from a licensor's perspective. How long do I need to give the licensee to give this technology a go, to make a go of it? How long do they need to prove whether or not they are the right licensee for me? And that's going to depend on the industry, the technology involved, the market that you're looking at going into. And then, what's the territory? I mean, you guys would all know, I'm sure, that one of the beauties of IP is that you can carve it up a bit like a pie, and you can give some of it over here and you can give some of it over here. So, you can license IP obviously to individual territories. Think about the idea of reversions is an important one. So, in certain industries or more mature licensees will often try to get worldwide rights from an IP licensor, but you've got to ask yourself as a licensor, well, is this person the right person to be the partner for my technology throughout the world, or do they have a better capability in one territory? If you are going to give your IP for large territories or the world, then think about reversions. If for example, if the IP hasn't been exploited by the licensee within a particular time frame, say, you can have this concept of, well, the rights will come back to you if they haven't done what you expect them to do within a certain time frame, and that's sort of one of the protections that you can get for as a licensor. And then you can carve up IP different ways, of course. So I've got their scope of license, but what I'm really talking about is sort of industry-specific applications or licenses. So you might have, for example, a a construction technology, for example, that might have application in the civil engineering, civil construction field. It might also have application in the civil building, residential building field, or it might have application in the mining and resources field. So your licensee for one of those industries, one of those markets, is not necessarily going to be the right person for the other one. So you can carve up the IP license in that way as well. Now, just to move on to payments and royalties, that's obviously a really big one for any licensor and licensee, of course. And you know, as a legal advisor, I often get asked, questions like, well, is this a good deal, what they've offered me? What should I be charging for this IP? And it's really one of the hardest questions to answer as a lawyer, because every technology is different, every industry is different, every deal that you do is different, and it's also going to be impacted on, all these things that we've got up here. If you're granting an exclusive worldwide license for a long time, you're going to probably want more money up front, perhaps, than you would in other circumstances. So, from a lawyer's perspective, I find it quite difficult to advise on this, but I can sort of give some approaches to the kind of structures that you see in royalty and sort of license fee arrangements. So you've always got to consider, for example, what's your upfront fee, your upfront license fee, against what might be a deferred or an ongoing fee, royalties, ongoing license fees. I mean, you might have, for example, a lot of confidence in your licensee partner to exploit the technology that they're going to make a success of it. So you might be prepared to, not take as much up front and take more of a risk on the fact that they're going to make a go of it, and you might exchange that for a higher royalty rate because you've got confidence in the partner going forward. Just consider whether any upfront fees are recoupable or are considered as an advance against ongoing royalties. Certain industries, more the entertainment type industries, you look at publishing, music industries, which I've had some experience in, very much customary to have any upfront payments as an advance, which is then sort of set off against your ongoing royalty arrangements. Are there going to be target payments along the way? Are there going to be milestones that need to be fulfilled either by one party or the other before a payment's triggered? From the licensor's perspective, maybe there's a certain development stage in the technology that's going to needs to be reached before a payment from the licensee is triggered. Are you going to have a minimum guaranteed royalty in there? So a baseline that guarantees you some kind of income, provides an incentive on the licensee to really put an effort into exploiting the technology because they know they're on the hook for minimum amounts on an ongoing basis. Look at the royalty formula very carefully. I get asked questions like, well, I've been offered 10% or I've been offered 15%, and is that a good rate? And the percentage on its own is obviously meaningless without understanding what that's actually being based on. And so, for example, just as a corollary of that, I always say to look very closely at any kind of royalties that are based on a profit arrangement or a net revenue formula. So the question when you see that word is well, what's it net of? What costs are being taken out of the ultimate royalty calculation back to the licensor, and who decides those costs and who manages them. That's something that, obviously if you're going to go down that kind of arrangement, you need to be very sure of what the calculations are. Obviously always get the right tax advice on different royalty structures, because it can become quite complicated. Just to make you aware, there are a couple of sort of databases and sources that you can go to for comparable agreements, comparable royalty and licensing information. Personally, I've got to admit I haven't had the occasion to use them very much. Royalty Source is one, the Licensing Executive Society is another one. But it tends to be a bit hit and miss. It tends to be expensive to sort of source materials through that. But because of the fact that deals are so different, and depending on the industry that you're looking at, you know, there may not be a uniformity of a licensing sort of structure or approach. But you know, just good to know that, you know, there are those resources if you're you know, looking around. So coming back to, again, the list of sort of commercial points, you know, in your licensing arrangements. So think about, is there going to be a consultancy aspect to this ongoing arrangement, you know, which might, you know, your technology might require some kind of ongoing service arrangement. Is that going to be, you know, exclusive to you as the licensor, as the person who knows the technology very well, can provide another sort of revenue stream that can sort of sit outside the royalty revenue stream, which might be a good thing for a licensor. Depending on the type of agreement, consider what sort of, you know, controls you as the licensor want to exert over your licensing. If it's a development of a product, you know, do you want to, you know, do you want to have control over, you know, samples? You know, what are the quality controls? Are you going to try to impose sort of technical standards on the development of products by the licensee? You know, you might want inspection rights at various intervals. Audit rights of financial information can be very important wherever you as a licensor are relying on payments which are effectively calculated and recorded by, you know, another party. You want to have the ability to, if you need to, go in and look at the financial records of that party to make sure that they're working things out the right way and that they're doing things the right way. KPIs, key performance indicators, bailout triggers, for want of a better word. This is what I mentioned at the start. If you are locking up your IP effectively, if you're making a big investment in a licensee where you're licensing something exclusively, well, if it doesn't work out, you want to have some checks along the way. So that might be in the form of, you know, the product has got to pass certain acceptance tests within a certain time frame. It might be that, you know, market trials of a product have to achieve certain benchmarks. It might be regulatory approval. It might be product releases by a certain date. It might be most fundamentally sales targets on an ongoing basis, on an annual basis. And the ability for the licensor, if they're not met, to either terminate the arrangement, or as an alternative, sometimes if it's an exclusive arrangement, it's quite common to see a right for the licensor to effectively remove that exclusivity so that the license can continue, but the licensor is free to look elsewhere if they're not satisfied with the performance that the licensee is sort of providing. The last couple that I've got in the list there very briefly are not really legal points. They're sort of more just commercial points. Obviously, if you're negotiating an exclusive license, you know, you're always going to get a better outcome from a competitive bidding process. If you can have a few licensees on the hook, that's a good situation to be in. And just a sort of a commercial comment, I suppose, that your attitude as a licensor, for example, to all of these elements that I've talked about and some of the sort of more legal technical ones that we'll talk about in a minute, they're influenced by you know, what you know about your licensee partner. You know, are they large? Do they have a good reputation? If they are, maybe, you know, you don't have to worry about them doing the wrong thing as much. Maybe you don't have to worry about liability as much. But by the same token, because of that, they may offer you a less attractive commercial deal. There might be a better commercial deal on the table from a licensee with less experience, less sort of proven reputation, but the risks might be higher. So these are all things that, you know, feed into your consideration of all of these elements when you're licensing. So now I'm just going to move on briefly, talk about what I'd say perhaps are some more sort of technical or legal points that you find in different types of license agreements. So from a licensor's perspective, control over sub-licensing is obviously an important one. You know, you're doing a deal with a particular person or entity or business. You don't necessarily want them to be able to sub-license, you know, bits and bobs of what you've engaged them to do. So a licensor will often want to have control over sub-licensing. Warranty is very important to consider. So an IP owner, an IP licensor will invariably be asked for, you know, IP ownership warranties, non-infringement warranties. But broader than that, and then just sort of flipping over to the perspective of a licensee for a minute. If you're taking a license of some technology, you want to know that it's going to do what you're expecting it to do. You want to know that it's going to do what the licensor is telling you that it's going to do. And particularly in the area of, say, software licenses or software and development licenses, then this is a common issue that I confront from a licensee's perspective. You want quite a detailed scope of, this is what the technology does, this is how it works, this is what it's going to do, and you want the licensor to stand behind that contractually with a promise that the technology is going to function in that way. But you see quite a dichotomy of quite a range of different approaches from licensors. Anything from, well, the software is just take it as is, all care, no responsibility, through to it'll function in accordance with our documentation that we issue ourselves, or some software warranties, for example, have got even time limited periods for 90 days, which I've always found a little bit funny, because it's not like it's a product that should break within 90 days, but there seems to be a bit of a convention on things like that. And then dovetailed in very closely with the issue of warranties is this whole idea of liability, more so sort of limitation of liability. So limitation of liability clauses, vendors, IP licensors will often be looking to limit their overall liability under the agreement, and that can take a number of different forms. From well, if it doesn't work the way I say it's going to work, well, we'll do our best to try and rectify it, but we won't take any responsibility for any liability beyond that. What we refer to as a no consequential loss clause is a common sort of limitation of your liability that a vendor will try to put in. So consequential loss is one of those legal phrases that you might have heard. It's still something that gets debated in front of the courts all the time in terms of what that actually means. But technically, consequential loss is loss that is more remote, that it doesn't flow directly from, say, a defect or a breach. So if something doesn't work the way it's meant to, it breaks and I've got to pay money to fix it, well, that's a direct loss. But if I've got downtime because of that breakage and I lose revenue perhaps, or if I lose a customer, or if I lose a business opportunity, that's getting into these areas that we call consequential loss. And that's something that, because that can potentially have quite a broad impact and be quite severe, that vendors, licensors will be looking to curtail, and it's quite a common sort of limitation of liability. But you can have other limitations of liability that are specific figures. It could be just a dollar amount, that the overall liability is limited to a figure, or it could be a multiple of fees or royalties or license fees paid under the agreement, or even to limits of insurances, for example, so that the licensor at least knows that they're not going to be, where it's an insurable risk, they're not going to be on the hook for more than what their insurance is going to cover. So that's often in the contractual negotiation process can be quite a thorny issue that goes back and forth. I know I'm conscious of time, so I'll skip through a little bit quickly here. Again, think about what you're actually licensing. What's the scope of what you're licensing? It's not always nice and neat. A patent, a trademark, sometimes it gets into the realm of proprietary information, trade secrets, that sort of stuff. So be careful, sometimes depending on the technology, as to what you're actually licensing. Think about what happens if we develop IP in the course of the arrangement. Often parties will work on developing a particular aspect of an application, a technology together. So who's going to own that if there are new developments? Is that going to be jointly owned? Is that going to be owned by the licensor? Is it going to depend? Is ongoing ownership going to depend, or ongoing use, I should say, depend on, depend on the licensor or the licensee agreeing on that? And what if the licensor makes its own advances in the technology separately? Software, again, new releases, new versions, is that automatically come under the license, or do licensee have to pay extra for that? How are you going to deal with all these things? Are all issues that come up. So that's the end of my run-through list on IP licenses. I just wanted to finish this section. Well, technology is getting more complex. That's obviously a very trite statement, but I just wanted to give you an example of a particular technology that I looked at for a client who was a licensee. It was a smart cities type Internet of Things technology. It related to control systems for public lighting. My client who was licensing this control technology was a supplier of lighting products, and they would then on-supply their products to councils, infrastructure providers, and they'd incorporate the control system, which they were licensing themselves, into the end package for the client. So what it looks like is you've got, in this example, you have a module which is supplied by the licensor that contains their proprietary control technology. You've got to put that into a product that's manufactured by the licensee. And then, of course, the product and the module have to talk to each other. So the parties have to design a bespoke interface so that the two technologies work together. And then when you put the system into practice, it's controlled by a user interface, which is probably a software as a service type online platform, which is a proprietary, technology or a platform of the licensor. And then the whole system is, of course, controlled by the end user, who the licensee, my client in this example, has licensed it to the council. So, when you think about that, the complexity of the interaction of that technology and how it's licensed, you can see that raises a bunch of issues. If it's a Internet of Things type technology or a lighting control system in this case, you can see that if something goes wrong, there's the potential for an accident. If a street light fails, personal injury. So there's certain liability risk there, and with the complexity of who's responsible for what, it's potentially quite difficult to work out who's actually at fault. Now you can't necessarily solve that problem in your licensing structure, but it means that you have to think very carefully about those kind of issues, how it's going to work. So liability issues, be very careful about who's responsible for which bits of the chain, which bits of the system. As a licensee, for example, you have to think about backing off your liability to your end client. So if you're licensing the technology on a certain basis that might limit the licensor's liability, then you need to back that off against your licensee. You don't want to be against your customer, because you don't want to ultimately be exposed to greater liability than what the licensor has if the licensor's at fault. You've got this slightly complex licensing, sub-licensing system that you need to consider. There might be, in some of these types of technologies, there might be third-party elements, involved. So in different Internet of Things technologies, you might have a payment gateway or something, which is a third-party provider. So what happens who's actually taking responsibility for that? How's that factored into the liability equation? What happens if your agreement with your licensor for the technology gets terminated for whatever reason? You don't want to be stuck with a contract with your client. You don't have the rights anymore to actually supply that technology. So what do? Are you able to negotiate that you can terminate your license in those circumstances? Do you have to have a backup technology, sitting there ready to go as a practical option? All sorts of things that you need to consider. So not to solve all those problems, not to go into them in any more detail than that, but just to give a bit of a flavour that, while, in an arrangement like that, while you're still going through that list of, the various things that you need to consider in terms of licensing agreement, just the different permutations and the complexity of it can require a little bit more thought. That was the end of part one. Mm-hmm. So we're happy to just move straight on to
I think so.
The Shareholder.
No questions.
Okay, all right.
That have come up, and that's
happy to. Any questions come through, we'll take them at the end. So I'm just moving through to. Let me just flick through. So just moving through to shareholder agreements. So it's slightly Slightly different area, obviously, more sort of commercial focused, business focused, often for, you know, exploitation of an IP technology, founders getting together, starting a company. I think the importance of shareholders agreements was brought home to me very much some years ago when I was involved for a client that asked me to give some advice on a board meeting that they had coming up. They ended up attending that board meeting, getting, well, I should take a step back. These clients were minority shareholders in a company. They had a shareholders agreement. They were also the executive management who, they were founders, but they were the executive management who ran the company and had been doing so for 6 or 7 years. The majority shareholder was the guy who put in the money, so he had the majority share. They had taken some advice previously on amending the shareholders agreement to change the way that directors could be appointed in certain circumstances, and they didn't take very good advice. I don't think they got very good advice, and it left a bit of a loophole open whereby the majority shareholder could actually appoint another director, an additional director in certain circumstances. He did that at this board meeting, and then he promptly kicked my clients, who are the minority shareholders, out of the company, terminated all their management arrangements, and effectively locked them out of the company. 2 years later, in the Supreme Court, probably $1 million in costs for those clients, all up in terms of lawyers, barristers, forensic, you know, accounting experts, and we finally had a resolution whereby they exited that company and got paid out, and you know, finally were able to exit the company. A lot of that could have been avoided if more thought had gone into the shareholders agreement, in the way that they appointed the directors, in the way that the control of the company worked. They could have protected themselves, and they could have saved themselves a lot of grief. So fundamentally, that leads on to some bullet points here as to why have a shareholders agreement. So fundamentally, that is one of them: to regulate control of a company, work out amongst the shareholders, how are we going to manage this company moving forward? How are we going to make decisions about the business that we're either starting or that we're getting into with other people? Corollary of that, establish protocols for shareholder management interaction, like the example I gave, you know, who is, and just to go on, define the roles and contributions of the shareholders, same thing, you know, what is every shareholder actually bringing to the table? Some shareholders are pure investors, they're just bringing money. Some shareholders are bringing IP to the table. That's what they've got, that's what they're contributing into the company. Some are the people with management experience, so they're going to be working in the company. So you want to use the shareholders agreement as an opportunity to record what you see as everybody's roles in this business. You might want to deal with how you're going to get money out of it. What's the economic return? Have a dividend policy. Are you going to distribute as much of your profit as you can? Are you going to try and retain some earnings against future growth or future capital requirements? What is the different, what are the outcomes in terms of financial outcomes that the shareholders are looking to achieve? How are you going to deal with future funding of the company? Every company is going to need capital at some point. So how are you going to achieve that? And I'll go into all these points a little bit in more detail in a minute. And then very importantly, and I'll spend a little bit of time on this, what are the exit mechanisms? You know, obviously everybody, well, they're not actually looking enough ahead when you get into these things, especially at the beginning, as to how and in what circumstances there's going to be an exit from the company. And part of the process of going through and having a shareholders agreement is trying to turn clients' attentions to those outcomes, which seem very far down the track at the time, but you know, you sort of have to turn your mind to them at the point where you're doing this. And again, where you've got majority minority shareholders, the majority will usually want to have say over most matters, often, but there are some matters that obviously as minority shareholders you don't want to be completely ridden roughshod over, and there are certain things that minority shareholders need to try to protect, even if they're not, even if they don't have a say in everything. So I'm just going to explore, I won't spend too long on this. There are obviously different life cycles within you can just flick through this, Andrew, different life cycles within a company's, you know, growth stages that you would be, you know, thinking about a shareholders agreement when you start off. your business establishment phase, you go through investment or growth phases. You might be looking at, private investors coming on board. You might be looking at venture capital investors coming on board. You might be looking at mergers of different businesses where you're going to need a shareholders agreement. Or then on the exit of particular shareholders where, say, a majority or a founding shareholder wants to sell down. They might not sell out, but they're selling down. Changes the whole control structure. If they're no longer a majority shareholder, you might need to revamp your shareholders agreement. Or if one shareholder leaves, again, it's going to change the control arrangements and a lot of other arrangements, and you might need to look at it again. So just to go into some of these elements a little bit more detail. So control of the company. So that's most fundamentally regulated by the board of the company. So very fundamentally in corporate law, the day-to-day management of the company is vested in the directors. That responsibility is for the board, and the shareholders, on the other hand, have sort of got the right, if the directors aren't doing the right job, ultimately to kick the directors out and replace them. So in a closely held private company, one of the most fundamental things that you'll deal with is the rights of particular shareholders to appoint directors. Can they appoint one director? Can they appoint two directors? And then based on that, how are you going to have voting work at both the board level and the shareholder level? Most fundamentally at the board level, you could have one vote for each director, but you don't necessarily need to. You can have voting along proportionate lines to shareholding. So you might have a company that's got a 70-30 shareholder, 70% shareholder, 30% shareholder. They might only each appoint one director to the board, but you might say, well, but the 70% shareholders director gets 70 votes for each, each decision, and the minority shareholder gets 30 votes. So you keep the voting along the lines of the shareholding proportion. And we'll look at an example of that in a minute. And also quorum. So a quorum is what is the minimum number of directors and types of directors that you need to actually form a legitimate meeting. Do you need one representative of each shareholder present to have a valid meeting? What happens then if people deliberately don't turn up to meetings? There are certain procedures that you could set for what constitutes a valid meeting. And this is getting into what I referred to earlier as sort of minority shareholder protection. So, often you will have the majority shareholders will want to be able to make ordinary decisions, but then as minority shareholders, or just as a way that if you as shareholders you say, well, if there are important decisions to make in this company, either business decisions or decisions that will affect shareholders' interests, then the majority, if someone's 51%, say, shouldn't just have the right to make all those decisions. We want to get to a certain threshold where we have a certain level of unanimity, if you like, not unanimity, or a certain level of consensus, I should say, before you can make particular important decisions. And the kind of sort of classes of decisions which you're looking at in these circumstances are issuing new shares or changing the rights in shares, anything that could dilute shareholders who then are not sort of participating in this, altering rights in the shares or in the constitution, fundamental rights of shareholders. And then you sort of have a class often of important business decisions. So, do you need 75% approval for significant acquisition or disposals over a certain value? Selling the business or a substantial part of it, or changing the nature of the business, entering a new business field, might require a certain level of, shareholder consensus. Incurring significant debts or liabilities, funding, raising finance, granting security over assets, fundamental decisions that have the potential to really affect the business is where you want to sort of often have some protections as far as that goes, or major contracts that the business is going to be making. So I just thought I'd give a little example here. I'll just turn up my page. So here's an example company. You've got a founder shareholder who's at 40% of the shares. You've got a CEO who's the guy running the company, or the lady running the company, got 25%. And then you've got three investors who just put in some money, and together they have 35%. So the shareholders agreement might say, well, the founder can appoint a director, the CEO can appoint a director, and the three investors together collectively got the right to appoint one director. So then you say, well, how are we going to make decisions in this? So in terms of ordinary decisions, you know, majority rules. So that means that any two of those directors, any two of the groups of shareholders can pass an ordinary decision. But for major business decisions, you might say, well, we need 75%. So that means that the founder's got to get the investors on board if he wants to bypass the CEO to make a decision. But, you know, the founder and the CEO together can't overrule the investors because they don't get to 75%. The CEO and the three investors can never get to 75%. Maybe the founder doesn't like that. Maybe he sets or maybe they agree that, you know, you set the major business decision threshold at 65% so that the founder and the CEO can get together and say, well, just, you know, irrespective of the fact that the investors don't like this, we know what's best for the business. We will have the right to make those decisions if we can't agree. So how that works out is where you set all those thresholds really depends a lot on what is the approach you want to take in terms of making decisions in the business, who's going to have the right to do it if you can't agree. And you might have unanimous, you might have some decisions that need to be unanimous no matter what. So you might say, well, if we're going to get a new investor on board, if we're going to raise capital or issue new shares, that's something that has to be agreed by everybody, which can be problematic and more common in that scenario in terms of raising capital is what we call rights of preemption for the shareholders. So you can't veto a right to raise capital because if a company needs money, it needs money. And the shareholders each have a right to participate in a capital raise, but if they can't stump up the cash, then they're going to get diluted. So that's another way of approaching that issue and giving some protection to shareholders to not be diluted, but by the same token, not sort of hamstringing the company if it needs money. I'll just run very briefly through this because it's more sort of administrative type stuff, but a shareholders agreement will deal with things like, you know, how often are you going to have meetings, what's the procedure for holding meetings, you know, preparation of an annual business plan that needs to go to the board, be approved by the board, what financial information is going to go to shareholders if there are shareholders who aren't necessarily also directors, you know, or even if they are, you know, what is the regular reporting to shareholders on financial matters, how often, what are they going to get, how are you going to regulate bank accounts and signatories, who's got to sign off on those things, all things that you can deal with in a shareholders agreement. In terms of structure, I'll just flick onto this whole slide, maybe Andrew just deal with it sort of all together. So often, you know, there are some special things to consider where you have shareholders who are also working in the business, so they might, you know, their equity may be linked in some sense to their employment, and you can have this concept of a bad leaver. A bad leaver if a shareholder who's also an employee in the business either decides they're going to resign within a certain period, or they get terminated from their employment for cause, that is for breaching the agreement, then you know, there might be repercussions on their shareholding. There might be actually a deemed offer of their shares so that they can be bought out. Sometimes it's sort of dealt with a different way. You can have what are called vesting schedules, where if somebody is coming in, say in a management role on day one, and rather than give them all their equity up front in return for services that they are going to render to the company over its life, you have a vesting of their equity over time, and you can sort of structure those sorts of things. Economic return dividend policy, we've talked about. Share structure, so you can, in more complex sort of structures, you can have different rights of shares in terms of different financial and economic rights in your share structure, so that some shareholders have preferential treatment either on preferential right to dividends, preferential rights in terms of an exit or in terms of liquidation, and often venture capital investors, professional investors will be looking for those sorts of protections. You might even have sort of a share structure that allows for a fixed return rather than an ordinary profit-based dividend return. And then one I've just been working on recently is a concept of flowering shares, where you it's sort of a bit like a trigger. If you are, again, a shareholder who's got some role to play in the management of the business, you might set them targets over a year or 2 years, and again, if they hit those targets, if the business hits those targets, then they have a class of shares that has special rights that will effectively flower, in inverted commas, and effectively get the rights to ordinary shares once you hit those triggers, but only if you hit those triggers. So there are a bunch of different sort of structures that you can put in place for more complex deals. And then sort of the last main area I want to talk about a little bit is exit mechanisms. So this is one that often spend a fair bit of time on talking shareholders through when you're drafting an agreement. In what circumstances can you exit the company? In what circumstances do you want to be able to exit the company? So one of the very common concepts in privately held companies, small shareholder companies, is what we call preemptive rights on transferring your shares. What that means is that if I'm a shareholder in the company, I can't just sell out to a third party without first offering my shares to all the other shareholders, right? Because as a shareholder, I don't want to wake up tomorrow and find that my partner effectively has sold out to somebody I don't like and I can't work with and I can't live with, might even be a competitor of the business for whatever reason. So one protection is to say, well, you've got to offer the shares, you've got to offer your shares to us, give us the opportunity to buy you out first before you go externally. What we call drag and tag rights. So a drag right is usually given to a majority shareholder, and it is the right to effectively force your minority shareholders to come along with you in a sale if you can procure a sale of 100% of the company. So as a majority shareholder, say you got 70%, you're always going to be more attractive if you can sell 100% of the company, not just your 70%. So a majority shareholder will want, in certain circumstances, the right to force the other shareholders to sell with him. But on the flip side, minority shareholders are going to want, in a lot of circumstances, a tag right, so a right to come along in circumstances, so that if a majority shareholder does want to sell out, does find a good buyer for the business, they want to partake of, or have a right to partake of an exit, so they can realise the value of their investment. So the tag right says that the majority shareholder can't sell its shares unless it makes an offer to the minority shareholders and it does a deal with its purchaser to make sure that the purchaser buys everybody's shares on the way out. And then I won't talk about this much, but 50-50 companies, shareholders agreements tend to be a bit easier in 50-50 companies because effectively, whether it's majority rules or unanimous, it's exactly the same thing. So you don't have to go into all those minority protections quite as much, but you can get a deadlock if you don't have agreement. And one of the mechanisms for resolving a deadlock in a 50-50 company is what's called a Russian roulette clause. And they've got various different structures, but effectively where you have a deadlock, it provides for some kind of mechanism for one or the other party to buy the other party out, or to make an offer to buy the other party out to resolve a deadlock. Because at the end of the day, if the shareholders can't agree and you have a deadlock and a company can no longer function, you've really only got the options of either one shareholder exiting and getting bought out, or there are remedies under the Corporations Act for the winding up of the company. But at the end of the day, if the company can't function anymore, then a winding up of the company is really the ultimate final resolution of that problem. And shareholders agreements deal with, where a shareholder is in breach of the agreement. They might breach a restraint, they might breach some other provision of the agreement. can often lead to, again, a deemed offer of the shares, sometimes at a discount to market value, whereby the other shareholders can then buy out the shareholder that's in default. Non-competition restraints, very important. So you generally have restraints on shareholders being involved in competitive businesses both during the time that they're a shareholder in the business and for a period afterwards. And the rationale is that if you're exiting and you're being paid out, say, by the other shareholders, and you're realizing your value, which is partly the goodwill in the business, you can't just start up a business that's competitive next door the next day as soon as you've taken your money and gone out. So there will generally be a period of a year or 2 years where there's some kind of restraint on competition. And you might deal with various different sort of valuation methods or mechanisms for any of these different exit scenarios, which might be market value, or it might be based on a formula, or again, there are many, many permutations of how different types of businesses, different types of shareholders approach valuation on an exit. We're running short of time, so just very briefly, this was another example I had just to illustrate the sort of the rights, the drag and tag rights, or drag rights as an example. So this is our same example. We've got our 3 investors. If you set a drag right, say at 50%, well then your founder and your CEO, who get to 65%, they can get together, they can find a buyer, and they can drag all the other investors along. But the founder equally could just get one investor on board and he'd have 50%. He can drag the others along if he finds a buyer. But the CEO and the investors together, what do they make up? 60%. Oh, so the CEO and the investors, if they get all of them together, they could then drag the founder. Well, the founder might not like that if he wants to keep control. So he might want to set the drag right at a 75% threshold. So then, different permutations apply. You could go on with examples like that quite a lot. But you can see that it takes a lot of thought at the initial stage, at the implementation stage, to think about these things, which you're not necessarily thinking about because you just want to get on and run the business. But often you've got to drag people's attention to these things because they become very important down the track when you're looking at an exit. And minority protection, look, I think we've talked about that already in the course of going through that. The anti-dilution rights, so your preemptive right on a capital raise to be part of it. I mentioned that. Tag rights, as we've mentioned. And just to sort of say at the end of the day, there is a doctrine in the law, and it's set out in the Corporations Act, which is known as oppression. And it's a very broad-ranging doctrine, but it's really based around minority shareholders being treated unfairly, in an unfairly prejudicial way or an unfairly discriminatory way. It can take a lot of different forms. One of them is, the one I mentioned, the example I mentioned right at the outset, where you are a shareholder and you're also running the company, you're in the management of the company. And the fundamental deal has always been from the beginning that you would have that right to do that. Then you get kicked out of it and you get removed from the management. Well, that's potentially a category of oppression. You can go to the court under the Corporations Act for relief, to either wind the company up or to force a sale. Exclusion from management is an example. And your remedies are buyout or wind up the company. And I think we're at the end, nearly just about on time.
Okay, well,
so that was it. And if there are questions,
very much for that. I've got the questions box open now, so if you have a question, please type it in now, and I'll read it out to Peter. Any questions locally to save me from having to ask my question, please?
Peter, how would you practically go about the auditing of royalties?
Practically, you generally appoint a third party, so you generally appoint an accountant or
it's not the auditor for the company.
No. So often you'll have a mechanism whereby it needs to be an independent person, or there might be a fallback to an independent person. Normally, the right is the right of the licensor to appoint their own representative to go in and get access. But if there's a dispute, you might have a residual dispute mechanism which might ultimately lead to the appointment of an independent person you know, people can't agree on what the outcome of a particular investigation has found. Yeah.
Any other local questions? Okay, well, I guess I'll ask my question then, unless somebody can save me on the internet. No luck. Royalties have always sort of amused me because they vary so wildly,
Yeah.
and I can never really understand how the negotiation starts. I mean, people talk about 1% and 10%, and that can be a massive difference.
Yeah.
How does that, how do you pick a first number?
Again, I think, that's a question that your lawyer generally can't answer unless you're very specific. There are some industries which have quite customary royalty structures. I think I might have mentioned in that entertainment area, so publishing, music, they have quite customary royalty structures. And so from that perspective, if you know the industry, you can say, well, this is a, publishing royalty, 12% or 10% of, your retail price is a proper royalty. But where it is a non-mainstream technology, or where it's not not something that gets licensed every day, it comes down to horse trading. You do have to do a bit of market research. You do have to run the numbers. You can sometimes try to, look into, do some research into comparative licensing.
So agreements that are coming in,
using those sources, yeah, that can be helpful. But yeah, where do you start? It's a good question. Yeah, it's a commercial question for people within the industry that you're operating in, as much as as your your legal advisor.
Okay, yeah, seems quite, I don't know, quite an alarming thing, like haggling in some countries. You've got no idea what the price is, and I guess ultimately the price is what somebody will pay for it.
Yeah, and sometimes you've got to be careful, because you also get where you have worldwide rights, you're granting worldwide rights. Sometimes, if there's a core territory like Australia where you're in, your royalty basis might be on one basis, but your worldwide licensee might try to actually have different bases for calculation where they're exploiting it internationally, because they might tell you they can handle distribution in other areas, but that's going to involve them having middlemen and intermediaries, and that they're going to want to take their cut. So your licensee then might only be prepared to pay royalties from those international sales on some kind of net basis. So then you have to look very carefully again at that. Well, what's actually coming out of that royalty that I'm ultimately going to get? So just got to be very careful.
Quite so. So if anybody else has any questions, can you please type them now? Otherwise, it's just gone 2 o'clock and we will wrap this up. I believe Peter's contact details are on the final slide of the PowerPoint presentation that will be made available to members in the section of the website. So if you have any questions, you could always ask him afterwards, I guess. Okay, so I'm seeing nothing, so I'm going to call it there. So just remains to me to thank Peter for his talk today. Yeah, very, very informative and eye-opening, I guess. There's an awful lot out there that that we don't know about, but it's good to hear that there are perfectly competent people in this world who do, and we know where to find them. Thank you.
Thanks, Andrew.